With reactions trailing the Supreme Court rulings in governorship appeals involving 8 states of the Federation over the weekend, the Apex Court berated some justices of the Court of Appeal over the quality of their judgments in the governorship election petitions brought before them, describing the judgments as perverse. In 3 separate judgments, the appellate court justices had voided the election of Governors Abba Yusuf, Khaled Mutfwang and Dauda Lawal on grounds of alleged unlawful nomination and sponsorship and deduction of alleged illegal votes. The Apex Court justices regretted that despite several decisions of the Supreme Court, the tribunals and courts lacked the jurisdiction to dabble into internal matters of political parties. Some justices could still go ahead and sack a winner of an election on grounds of political parties, primaries, nominations, or sponsorship. Well, a senior advocate of Nigeria, Michael Zokomen, who was on our nightly news program, Newsnight, said the Supreme Court spared no words in criticizing the rulings of the appeal court on the governorship elections disputes, stating that the Apex Court used judicial koboko to flog the appeal court while giving verdicts on the matters.
The Supreme Court today spared no words. They used legal and judicial koboko to flog the Court of Appeal for what they termed miscarriage of justice, perverse judgments. In many of the cases, particularly in the Plateau State, 2 senators' positions were reversed, 3 House of Representatives were reversed, about 11 House of Assembly were reversed. If all these cases have gone to the Supreme Court, all of them will have their seats retained. On what ground were they reversed? The Court of Appeal surprisingly was talking about saying PDP had no structures in Plateau State. When the PDP structures, membership of a political party of the PDP, nomination, congresses, primaries, when did they become part and parcel of matters that the court can have jurisdiction? Today, the Supreme Court said not even the election tribunal had jurisdiction, let alone the Court of Appeal, and they voided the decision on the governorship. They would also have voided the decision on the 2 senatorial candidates, the 3 House of Reps, and the 11 House of Assemblies. Injustice has been done to them. What is the remedy now?
Michael Zokome stated what a lot of Nigerians and even lawyers have said. I mean, they're even saying that the collation of results in elections in Nigeria end up at the Supreme Court, which shouldn't be. I mean, the Supreme Court is tasked with so many issues, not, judgments on results. Let me take Atiku's tweet. He wrote, the Supreme Court's decision represents a significant victory for the people of Bauchi, Plateau, Akwa Ibom, and Zamfara states, and is undeniably a triumph for constitutional democracy. I extend congratulations to Governor Abba Kabir Yusuf of Kano State, of the New Nigeria's People's Party, on his commendable legal victory. This moment also provides an excellent opportunity to restate my commitment to the idea of a unified opposition is crucial for strengthening democracy in Nigeria. I am more than ready ever to lead this endeavor, working alongside esteemed leaders and governors for the betterment of our nation. I mean, in Kano State, the supporters of the New Nigeria's People's Party trooped out in large numbers on Sunday to welcome Governor Abba Kabir Yusuf back to Kano after Friday's judgment of the Supreme Court, which affirmed his election. The governor was received by the crowd at Kwana Dongara amid singing and dancing. Let's take a look.
One of the justices of the Supreme Court, Inian Okoro, did say that I know people will have suffered from this. I mean, should people suffer from the justice system that is supposed to get them justice?
Thank you. I happened to have been at the Supreme Court on Friday, so I sat through all the 8 judgments. Some of the reports in the media actually were passed as comments, remarks after judgments were delivered. For instance, there are well-articulated positions that resonate with those of us who are concerned about the public in our justice system. But I just wish to caution that when the hard copy of the judgments are released, if some of these comments don't feature there, there should be no insinuation that they have doctored their judgments. It's normal that for cases of those weighty disputes, the court's view can be expressed in different ways. Now, the first judgment was Lagos, which was read almost in full by Justice Garba. But because there are so many of them, after Lagos State judgment, most of the other ones were just delivered in summary. Each of the justices that delivered the judgment will highlight key points in the judgment. For instance, the Kano judgment, which was a condensed judgment in one appeal, intended to cover 9 appeals. There were 9 appeals from Kano, from the judgment of the Court of Appeal. But at the hearing, I happen to have been involved. The Supreme Court invited counsel to agree on which of them was the signature judgment that they thought, if taken, will address all the issues. And they agreed on the appeal by Governor Abba Yusuf. And the judgment in that particular appeal was the one that all other ones were to abide. So I just wish to make that observation that some of the things that were reported were correctly reported, but they are not necessarily part of the actual judgment delivered, because most of the judgment were paraphrased. So with that clarity, with that clarification coming, I think we can proceed. I believe that of the 8 cases there, Lagos turned on the issue of citizenship. Kano turned on the issue of invalidation of ballot. Zamfara turned on the issue of inconclusive election. Plateau turned on the issue of PDP not having a structure and a judgment of a high court having not been obeyed. Alex Oti's case turned on the issue of his alleged decampment, belated decampment, which they claim now denied him right to contest, that his name was not on the Labour Party's register because he was originally an APC aspirant. Cross River was about alleged non-qualification of the governor on account of his not having attended a secondary school. When the governor had been a senator, he's a graduate that's undisputed. So I think that essentially, then Bauchi turned on Section 73-2, which interestingly was a test case, and their lordships, while they found that the issue was well taken, that it was not shown that it affected the election in terms of audit trail of election materials. But the critical cases, which I believe the populace are interested in today, will be Plateau. And Plateau because there are a number of outstanding issues from Plateau. 26 or so legislators have had to have their victories undone through the court based on the same set of pleadings and facts that the Supreme Court reviewed and held were not available as basis for election petition, and so returned Governor Mutwang. It then meant that if those other people had a chance to have gone further to Supreme Court to challenge the judgment of the Court of Appeal along the same line, the rule of certainty suggests that they probably too will have emerged victorious at the Supreme Court. But unfortunately, on the first blush, it does not look as if they have any further recourse. But I think in the course of this discussion, I take a slightly different view. Judicial redress is clearly separate and distinct from administrative redress. Any approach to NJC is not an approach to Supreme Court or to any court for reprieve. It must be an attempt to invoke the administrative powers of NJC, usually which is disciplinary. The NJC does not review judgment, cannot review judgment, cannot reverse judgment. So it doesn't appear to me that that is a viable option to pursue, unless the whole idea is simply to just have the judges affected to be sanctioned. And that will not actually address the real issue of justice that the public and the affected litigants are looking at. So, and in that respect, I've not heard it being said that the justices that were involved in those cases were in any way guilty of malpractice or fraud. Because if that was the case, even if that was the case of Umana and Atta is to the effect by the Supreme Court that if a judgment is obtained by fraud, it does not entitle the Supreme Court to reopen or revisit it. You can only go after the judgment by way of an action to challenge it as a judgment obtained by fraud, by a fresh action. So that is out of it. If it's about the judges having gotten it wrong, which of course is the implication of the Supreme Court upholding the Plateau governor's case, that is also one of the prerogatives of judges, that they can be right, they can be wrong. They can be grossly right, they can be grossly perverse. That also does not impact on the judgment itself as a valid judgment until it is set aside. It, however, says a lot about the quality of the judgment and the judicial officers involved. We should, in any event, reflect on their career progression, especially as they are Court of Appeal justices. They still have one more ladder to climb. Judges who are involved in this kind of thing, especially where the Supreme Court had to come out heavily to sanction and excoriate them, should by now be reticent. They should be contrite, and that we cannot afford judges being open to any form of review. It means that those kind of judges need more study at the Court of Appeal before they are ever considered for elevation to Supreme Court. It's not new. I've recalled a case of a judge of the Federal High Court against whom there was a petition, and the decision of NJC was that because of a demonstrable lack of competence and capacity to understand law, he should never be considered for elevation to the Court of Appeal. It's in the record. So it doesn't happen. In this kind of thing, what I will expect for those who seek, other than judicial recourse, some form of other mitigation or reprieve to do, is to see how they can make a case why those judges who are involved in this may have to have their progression delayed so that they can learn better. They can get more seasoned before they are considered for more onerous responsibility in the hierarchy of our court. So that's what I can say for now. In terms of the options available, now I've said that I take a different view. It's like because if you look at our precedents, the first attempt to try this kind of thing, taking a legislative house election judgment at the Court of Appeal to Supreme Court, was in the case of Onugu Uluchi in 1999, as we were transitioning to the democracy. The senatorial election, I think, is from one of the eastern states. And the Supreme Court were very clear that because the decree that established the appellate process for the transitional election gave Court of Appeal final authority to determine those matters, they had no judgment. Whether the Court of Appeal was right, was wrong, was perverse, it still does not open a window for you to come and review or test the correctness of their judgment at the Supreme Court. So they declined to hear that case. However, fast forward, in the case of Ucha and Onwe, the Supreme Court took a different view in respect of a legislative senatorial election from Ebonyi, where a senatorial candidate of a party was substituted unlawfully for somebody who contested for governorship, and that person was returned as winner of the election. The matter went to court, to the tribunal, and to the Court of Appeal. The Court of Appeal ruled that, took a decision, and the man went to Supreme Court. Supreme Court entertained that case and returned Senator Ali Ucha as senator because from the records, the person returned was shown to be governorship aspirant and candidate of the party. And he said he was not validly substituted. There was never a substitution. Supreme Court, looking at the case, then entertained the case and they returned Ali Ucha as senator. Even notwithstanding that the constitution was clear, 2463, that finality of court of the judgment election petition appeal other than governor and president cannot be reopened. So the Supreme Court find a basis to do that on account of the fact that if that issue had gone the right way, the Court of Appeal had no jurisdiction to have taken it. Now, the second case that I also like to reference is the Dangana and Usman. That also was a case where parties, PDP, I believe, and APC had issues about the procedure for nomination of candidate of one of the parties, claiming that INEC did not supervise or monitor the primaries. So they made it one of their complaints in their petition, I think the tribunal overruled the objection to the fact that, on the point that it was a pre-election matter. On appeal to Court of Appeal, the Court of Appeal reversed the tribunal. Interestingly, they then appealed to Supreme Court as if it was as of right. And Supreme Court held that court jurisdiction is never conferred by agreement. It's not conferred because it is in the interest of justice. It's also not denied simply because it's inconvenient. And that therefore, in that case, the Supreme Court entertained the case and decided the matter and returned the candidate of the party that was declared by INEC, saying that Court of Appeal did not have jurisdiction to hear the matter, because by the very nature of the case from day one, it was having to do with election matter. So these two cases, if properly, analyzed, might create a window, a pathway for the Plateau victims of the decision in those cases to, in this case, invoke what I call the inquisition jurisdiction of the Supreme Court, which is jurisdiction for the court to determine whether or not it has jurisdiction. How do you do that? I think that applying to Supreme Court as a test case for leave to appeal that judgment on the basis that what the Court of Appeal, sitting as a tribunal appellate court, decided was not a matter for them, neither was it a matter within the context of the election tribunal that heard the matter. In which case, if it had gone the right way, it would have ended up at the Supreme Court. That being so, it's a matter that Supreme Court, on the authority of Onwe, that I said, Ucha, and on the authority of Dangana, Supreme Court may find a reason, especially given the indication from them that they found that judgment to be most unjust, whether it's in passing or not. It will be very easy to satisfy the court that there is an arguable and peculiar case in this instance, not because Supreme Court will be sitting on appeal over judgment of Court of Appeal, but because the Court of Appeal in the first place did not have jurisdiction at all to sit on that matter as an appellate court from a tribunal when it has to do with party structure of one party and their primaries and the judgment of a high court that went to Court of Appeal as a pre-election matter. So I think this window can be explored by way of applying to Supreme Court for leave to appeal on ground of jurisdiction. That the jurisdiction to determine that issue to finality vested in the Supreme Court if they had gone to the right court. And that having gone to the Supreme Court of Appeal in the wrong way, there's a window now for Supreme Court to assume jurisdiction whether or not it was right for that matter to have been taken up by the Court of Appeal. And if it so finds that it is not so, Supreme Court, in the case of Iyoto, has jurisdiction to now say, retrieve the certificate of return given to those people based on the judgment and give it back. Called that there was supposed to have been one of the panel members who went somewhere in Adamawa for a function and seemed to be justifying the reason for their judgment. But even that, I think it's a bit off mark for the judge, knowing that the matter was still fresh, to go and be making comments about it. But that having been said, what I think people were worried about in the respect of Plateau was that a single panel heard all the appeals. And that did not allow for diversity of views. Because even when they sit as 3 or 5, they still have conferences where other members of the Court of Appeal feed in their views so that they can have common thoughts about how some of these similar issues can be decided. It's not clear to me if that opportunity presented itself in case of Plateau. We did so many of these cases, and in each of the states, you have different panel for governorship, different panel for senatorial, just so that they can spread the load of work, the workload. So I wouldn't know. That might have the idea that maybe there should be uniformity of decision might have been the underarching reason why the same panel. But it's now been shown that it was perhaps a wrong approach to go. The other point to make is that in this kind of matters anyway, Court of Appeal is the final court. And after the final court has given a decision, anybody can speak. That's why I'm able to speak today about all these judgments. So it's not even out of place for a judgment that has been determined to finally for a judge to comment about it, for academics to comment about it, for the public also to critique it. So I guess that's the impetus for people making comment about knowing that it's supposed to have reached the final bus stop. But from what we are seeing now, and given the stand or indication of the attitude of Supreme Court, I think that there's a window that something can be done about it judicially without sacrificing constitutionalism. Beyond that, however, it's not every case that requires judicial solution. This is already a case of a miscarriage. There is a mishap. The entire polity normally should sit down when we are interested in the country to say, look, are there other ways we can address this issue? For instance, if this was something that happened in a country where people have integrity, all members of the National Assembly, House of Assembly, that benefited from that judgment, in view of what Supreme Court has said, should on their own offer to resign, and then they all go for by-election. This is what I would have expected to happen from people that have integrity. But you see, when we as lawyers cannot even agree on whether the right approach is it, then you can't blame them. But I'm just saying, in case some of them are thinking in that direction, it might be the honorable thing to do. So everybody will have a second chance. The injustice done would, one way or the other, have been in a way mitigated. That's one option. The other option also is that the judges who can be shown to have malevolently, traduced or breached the rights of the litigant in this case, even if they are on course to go to Supreme Court now, the president of Nigeria has power of veto over nominees, even although they have been cleared. You remember that for over a year, judges who are cleared to go to Supreme Court, President Buhari did not do the swearing in until after some time. So if there is any of them that there's a very serious concern about his fitness to go to Supreme Court in the interest of the entire country, the president can, without necessarily rejecting, he can withhold his invitation for swearing in. There are 3 judges that heard the matter. So if something went wrong, that does not necessarily mean that they did something fraudulently. It might just be their own view of how the matter should be decided. After all, at the tribunal as well, the tribunal was the originator of the whole crisis that went to his chambers and made it clear in Judgement that they discovered 165,000 ballot papers that were not stamped and used that one to do a new arithmetic and return somebody else. Somebody else that was not even a party in the petition. The person who had even congratulated Governor Abba Yusuf that he was not interested. So I don't think it is fair for me. But if for any reason, those who have information that they think are weighty enough to prevent anybody from going to Supreme Court, this is the time for them to act. And it is not to NJC anymore. It is not to National Assembly because they have been cleared. It is to the president. If people actually want to put their mouth where they are, whatever, I don't know where I forgot
the money where their mouth is.
Then they have to go after it. You remember before the election, thank you very much. You remember before election, Rufai, you remember I made the point that this election was more important because of the power that the president would wield to appoint at least 10 judges of the Supreme Court on assumption of office. You remember I said it. Yeah. I was shocked that Labour Party and all whatnot that were in the National Assembly, they did not take these justices through any rigorous screening. As opposition party, they were cleared in less than 24 hours, which is scandalous. I remember that before Trump left office, he pocketed many appointees to the bench against whom he did not feel comfortable, because that's part of the prerogative of the president. I do not see why, when for the first time in our history, we are having a president who has a chance to appoint 10 judges at the same time, who will rush the process and not get the best value for the exercise. I think what has happened is an eye-opener for us to revisit how we take the issue of screening justice at the happiness level, where they have the power of life and death over all of us. We should take it more seriously. And an opportunity to probably, tinker with that process. And just like the president has been reacting to other concerns of Nigerians, is it corruption in the material ministry, the issue of palliative subsidy and everything, he's been responding. I think there is sufficient noise made and good case made. The president may respond one way or the other to this. I'll give you one simple example of how things like this are done when statesmanship prevail. There was justice of the Court of Appeal that was going to Supreme Court. At the point of his being recommended, there was a petition that was written properly. That petition prevented his elevation that year, and somebody else from his own zone was elevated. To Court of Appeal. By the time the opening came in Supreme Court from that same, they corrected that error by ensuring that he went to Supreme Court before the other person. The petition was totally biased. And it was his case that was used to now say that if anybody is due for recommendation, objection and all whatnot against him must come early enough for him to be able to respond.